Welcome to Protect What Matters, Estate and Elder Law with Tim Murray.
Welcome back to Protect What Matters, Estate and Elder Law with Tim Murray, a Winamac lawyer in Indiana. Tim has more than 35 years of experience helping Indiana families with estate planning, probate, and elder law matters. I'm your host, Evan Mack, and today we're talking about what documents make up a complete estate plan in Indiana and what each one does. Tim, sir, welcome back.
Evan, great to be here again. Thank you so much.
Good to see you, sir. Tim, a lot of folks assume an estate plan is just a will. In Indiana, what documents usually make up a complete estate plan?
I think that's a kind of a customizing question in a way. A lot of people have the same types of documents, but some people have different ones. And I think it's a unique situation for each individual. First of all, sometimes I have people come in and they'll sit down in my office and like, well, I have a will, and then they get confused, and because so many things are named in similar vein, so they hand me their living will, and a living will is not a last will and testament. It's a healthcare document, but some people get confused and they've had it for years. But I think I go out and give a lot of talks and maybe like a lunch and learn, in addition to my almost 2-hour boot camp that I put on here in my office. At my lunch and learns, I condense things down and maybe just change the conversation to what are the 4 or 5 most important documents that anybody needs to be considering and then have in their estate planning portfolio. And I believe that the 2 most important documents, are, in addition to a will, are your advanced directives. Then everybody needs a will, and the 4 or 5 documents are like I just said, and then I go into a brief explanation and entertain questions about those. But people who just do a will don't realize that there's so much more to it than that. And I think an even longer answer to the question, to add to what I've just said, is that I have a lot of people that come into my office and they sit down and like, we just want to do a will. Okay. And they get up an hour later and they're scratching their head going, wow, I didn't know there was so much more that we have to think about.
Yep.
Just doing a will. And I think that's the best answer I can give you for that.
Absolutely. So, can you explain what a will is designed to handle and what parts of life it doesn't really, address at all?
A will is going to handle any assets that you may have that you've kept in your name only. So if you have, for instance, a checking account or a savings account that just has Tim Murray's name on it, it doesn't say payable on death. It doesn't say transfer on death. There's no joint owner, just Tim Murray. That's going to be a probatable asset. Probate is what your will is going to be taking care of, probate assets. A non-probate asset would be like, if I die and my life insurance pays to my wife, that's a transfer that is not covered by my will. So you can make things non-probate transfers, payable on death, maybe, those kind of things, or a transfer on death deed. And I'm not going to say those are always the best things to do because they're tools that have their place and they don't have their place. But your will is only going to cover situations that are assets that are in my name only, and then they get probated. And the will then can cover a variety of other things. So maybe I don't want to have money go to a 15-year-old kid or grandson, child or grandchild. Or maybe that I have a child or a grandchild with a disability, and if I leave them any money, it could get them kicked off their disability. Those are things that people don't think of that need to be prepared for and put into people's will, and we put those in trusts also, but in will planning. And then we can also put in other specific things like customized things, like specific requests, certain things that you want to have go to certain people. Anything you want to have taken care of. And this usually only pertains to property, and it's hard to get anything else into a will that doesn't just pertain to property. You can put some legacy planning in. You can attach legacy letters and things to a will and to any kind of estate planning to let people know, hey, this is why I'm doing this with this asset, or this is why I'm doing this with the property. And I want you to have a family get together, or, different things. So we encourage those kind of things to go along with the will kind of planning.
So Tim, medical decision-making documents often get overlooked, but how do powers of attorney fit into an estate plan? Why do they matter even if someone feels healthy right now?
I think that the most underrated and overlooked documents are the financial durable power of attorney and our healthcare directives. To me, those are the most important documents that anybody can have in their estate planning. A lot of people think, well, they'll just take care of it. I don't need to do anything. They'll know what to do when the time comes, or they'll make healthcare decisions for me. And in my boot camp, I talk about the next of kin statute for healthcare decisions. If you don't have a healthcare directive that you'll appoint someone to make medical decisions for you, then the hospital staff's going to say, who's Murray's next of kin?
Hmm.
And there's a list that they go through. Mom and dad, am I married? Are my mom and dad alive? What about my brother? And, I have an older brother, and, I'd do anything for the guy. But, he and we grew up and slept in the same bedroom when we were kids, but and have shared a lot, but we've never talked about healthcare decisions, and he wouldn't know the first thing about what I'd want to have happen. And so why would I want to let a statute appoint him to make healthcare decisions for me? That's the first thing I think people need to know, that if you don't appoint someone, you may have someone that doesn't have a clue, or that you don't want making decisions for you. And as far as the durable power of attorney for financial and legal matters, well, if you don't have one of those in place, there's no next of kin statute to take care of that. If you don't have someone appointed to do that, there's a strong likelihood that you're going to have a guardianship placed over you if you're incompetent. That means if you're not capable of taking care of your finances and your property and paying your bills and those kind of things, you've not appointed someone to be your person, your attorney, in fact, then your family or someone may be petitioning the court to get a guardianship just so they can take care of those things. And I always encourage people to do those. And in my boot camp, I have a slide, and at the bottom are the guardianship terms, and at the top's the POA and the healthcare directive. And I tell people, I can do these for a few $100, but a guardianship's going to cost thousands of dollars. And if that doesn't persuade you, nothing will to get the PLA done in the healthcare directive. So,
Yeah, Tim, can you share a situation where someone had a will in place but was missing another key document, and it kind of created complications while they were still alive?
I think that the biggest thing is to kind of bootstrap onto what I was talking about. I had a young man that was in an accident, and he was 19 years old, and he didn't have a power of attorney or a healthcare directive. And he was in an accident and had a brain injury, and he was in a hospital for 45 or 50 days. And his parents came to me and said, we need to get a guardianship over our son. And I'm like, well, why? And they said, well, we don't have a power of attorney. Now, they were able to use the next of kin statute, okay, that says they can make healthcare decisions for their son at 19 while he's in the hospital. But they can't make legal decisions for him. And he needed to be moved from that hospital into a rehabilitation facility because of his brain injury. Had to learn how to write and do some things all over again because of that injury. And to sign him in to the rehab facility, they had to have legal authority to do that, and they didn't. So we had to petition the court and get a guardianship established, and that takes time. We have to talk to doctors, and we have to gather evidence. All these things take time and a lot more money. So, and I like to tell this story because these things are for all age groups. Okay, these are not just for old guys like me that need to have a will and a power of attorney and a healthcare directive. These things are for people of all ages, that they need to have these documents in place because this could happen. So mom and dad are frustrated. They can't get him signed up and legally into this rehab facility. They have to spend time, effort, and a lot more money. And in the meantime, their son's waiting and not getting the help that he needs.
So beneficiary designations don't always feel like estate, planning to people. How do things like retirement accounts or life insurance fit into the overall plan for people?
The thing we want to talk to about people is, do we want to leave money directly to someone? And I know that sounds like, well, sure, why not? Or why wouldn't we? Well, if if I die and my insurance policy pays out to my daughter and she has my grandchild, but what if she dies before I do? And I don't have any other designation on that, and it goes to my granddaughter, and maybe she's 10 years old. Or a better example would be like a bank account that's payable on death. Because if my daughter dies before I do, then the law in Indiana says it'll go right on down the line to my lineal descendants. So that would go to my granddaughter. And, is she financially old enough to be financially responsible to handle, well, I'd like to say I had $100,000 in my checking account, but I don't, but however much money I have, is she going to be financially responsible and mature enough to handle that direct, boom, baby, here it is? Or is the guardian who's taking care of her going to take advantage of that pile of cash that's now been given to a 10-year-old?
Mm-hmm.
Or is she on some kind of disability that if I were to leave money directly to her, it would get her kicked off her disability? Or even better yet, is she going to be going to college? And when mom and dad sit down to fill out a FAFSA form, and I don't know if you're familiar with that, but let me tell you, FAFSA forms are the bane of anybody who has kids going to college. Then if I leave money directly to parents or to that child, they're not going to qualify to get scholarships and grants and these kind of things. So the underlying theme here is, why would you leave money directly to somebody? There's planning to take care of these situations and to help the situation out. That maybe it's not that they're not going to get the money, but why don't we have it go a different path and ask some questions? So does that person have any issues in their life that we don't want to give them money directly? Are they on a disability? Are they too young? And then we have these safety nets built into our planning that are going to handle and take care and manage their money for them until they become old enough to get it themselves. And then we pick an age where that happens. So, but I digress. I think maybe I'm getting a little too deep here on a topic. So,
but Tim, but at what point does a trust start to make sense? When is it usually more than someone actually needs? If that ever happens.
I don't know if it can ever be more than what someone needs, unless, there's a lot of people that go through life and they've been able to do and have a wonderful life. And when they die, they don't have many assets at death. And I say that kind of tongue in cheek because a lot of people think that, well, I don't need a trust because I just don't have that much. And that's not the situation. A trust is for someone who, I always ask them, well, what do you want to do with what you have? And how do you want things to play out? I think that different types of trusts serve different purposes, and we have to talk to people, get to know them, what their desires are in life, what their fears are, what their concerns are, because a revocable living trust will serve a function for someone over here if they want to have X, Y, and Z play out or do things. But an asset protection trust over here is going to do maybe some of the same things, but in addition, it'll protect assets from lawsuits. It might protect assets from nursing home costs, all these kind of things. Some people, I'm going to use all my money up to take care of myself and my health care. And if that means I spend every dime on a nursing home, that's it. And my kids are all well enough off, they do that. And then the flip side of that coin is, I don't want all my assets to go to a nursing home and be spent if I have to go there. What can I do to protect them and keep those assets from being used up that way? Because I do want to leave my kids something. And there's no wrong answer to any of these things. It's like we talk to people and their answer is the right answer on what type of trust to use. And I let them know if I think it's going to be overkill. If there's something that you may want to do differently or add to or take away from. So, but every individual or family or couple is different, and the customized language we put into these trusts to handle certain things is quite often different.
But Tim, how often do you see problems come up, not because these documents were drafted incorrectly, but because they were, outdated or no longer matched to someone's life or, the things that have happened to them in their life?
Oh, sure. And too many times, and I think a lot of it is two reasons. Number one, they didn't get documents updated. And number two, they've never gotten documents done to begin with. They just always thought, well, things will work out, or the kids will take care of it later. And I've had a lot of different situations. I had one situation where a man and a woman had been married before. They'd both been divorced, and they both had kids from their previous marriages. They got married. They didn't have any kids of their own. And he had done a will that left everything to his wife. And then, if she died before him, left everything to one of her kids and his kids. Well, they divorced. And Indiana law says that, when you divorce, the guy's will is not invalid, but only invalid to her. So when he dies, she didn't get everything. So a few years later, they get remarried. Okay. And now, Indiana law, and then the guy dies. And so we're dealing with a lot of dynamics there so back when all this happened, Indiana law is that she's removed from the will and everything else goes forward. Indiana law has changed now so that if that situation were to happen now, the will would still be in effect and she would still be included in the will. So I have situations like that. I have situations where people don't have the toughest ones are when people don't have any planning at all. And they don't have any direction in the deed, or they don't have any direction in a will done up. And we have to track down relatives, or sometimes I have to ask people, well, you've listed 2 kids here as your stepkids. Do you have any? And I've asked you if you have kids. Yeah. Well, do you have any biological children? Well, yeah, but they're not getting anything. But, see, if I don't dig and keep asking questions, they're not going to tell me because they don't want those 2 kids to get anything. But if we don't address the situation and take care of things, lawsuits, and
yeah.
So anyway, it's frustrating sometimes if they would just be up front and lay it all out for me and tell me why they don't want those two kids to get anything, we're going to take care of it.
There you go.
We're going to make it happen for them. But withholding information and not letting us deal with it the proper way leads to trouble. So, yeah.
And speaking of that, though, Tim, for someone trying to be responsible without overcomplicating things, how do you usually suggest thinking about an estate plan as a whole instead of that stack of paperwork that you can get to some of the time?
I try to get people to understand that we want to put their voice into things. We want to have them getting things done the way they want them to. If that means naming names or people we don't want to have involved in planning, or maybe there's a relative or someone that they don't get along with very well and they're afraid of what that person might do, then we put safeguards and we can address those issues. But we don't want a document that just gets a result. Okay. We want to have a voice and we want to have a plan that's a living, breathing thing that has your voice in it. And whether that's in a trust or in a will or in your advanced care directives, we want to make sure that everything gets written up and presented in your planning that's going to address all your issues with your family, with your disabilities, with life and death and all these things. And that takes time. And like I said, I tell people this is not a one and done meeting with me. We're probably going to meet a few times so we can get, everything we need to get so we can do proper planning for you.
Awesome. Tim, thank you so much for your time, sir.
Thanks, Evan. Good to be here.
Awesome. That's it for today's episode of Protect What Matters, Estate and Elder Law with my man, Tim Murray, a Winamac lawyer in Indiana. If you'd like to learn more about Tim Murray and the work he does at Murray Law, you can visit tmurraylaw.com or call 574-946-7819. Thanks for listening. And don't forget to leave a review, and subscribe to the show so you do not miss the next episode. Thank you so much, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.